Welcome, everybody. I want to thank you for turning out here. As I look out my window in beautiful Northeast Ohio, we're in the middle of what could be charitably called a blizzard. So we're glad everyone could make it. My name is Chris Cooper. We're here for an additional a webinar in our series of webinars for small business owners on business succession planning and exit planning. And we're really pleased today to have Neil Waxman from Capital Advisors Limited. It's a financial advisory firm in the greater Cleveland area. So, more than probably anyone that we work with is responsible for the success of the program over the years, so we're pleased to have him here today. Neil's going to be talking about integrating your estate and succession plans, and the title is Ships Passing in the Night. And one of the issues that we see often with business owners is they think by creating an estate plan, they've created their succession plan and vice versa. And hopefully what we'll be going through here today is to give you a little bit of insight on how to integrate the two plans and to really accomplish the goals, both private goals, personal goals, and business goals as you move forward through this process. So I think without further ado, I'm going to turn it over to Neil.
Thanks, Chris. I appreciate that. And in order to give you some examples on how integration takes place, you obviously have to have some basic global look at what succession planning is, and then the components of estate planning, which I will spend a significant amount of time on this morning. And then I will talk about the integration process as I go through the steps. But I have also included a couple of, in fact, three. I gave you a bonus one. It's like the CDs with the hidden track, you know. But I've given you a bonus case study in the end. So I've given you a case study that will, on the slides, give you an example of when succession planning and estate planning, or corporate planning and estate planning, collide, and the problems that can happen. And I've given you a real live examples from the annals of the IRS's very interesting book. And then the last two will be examples of where it has worked and how it can be integrated with some examples from work that our firm has done. So I appreciate everyone who's on board here. I'm going to leave the phone line open rather than close it, so you don't have to use the online chat typing service. And so feel free to pipe in with any questions or comments you might have as we go through this. And with that, I will begin with what I believe the 6 ingredients are of succession planning. And as you can see there, that's my recipe. 2 parts psychology, 2 parts social work, 1 part finance, and 1 part tax. And if you don't combine them in the right order, it could explode. What does that mean? It means that you need to deal with the emotional issues first and define those things, which I'll talk about as we move through the slides, before you get to the finance and tax aspects of it, which can be the tools and the techniques. And all the things you read about, all the company failures in privately held succession planning, and there have been books written about it, and there are many, many examples, usually happen because tax and finance planning was done either in advance of the other or in the absence of dealing with the other issues. The next slide then is what I believe are the 3 components of succession planning, and the philosophical part, which is the first 2 parts of the recipe. And as it states there, these are refinement of objectives. You know, so philosophy is who, how, what, where, when, and then the mechanics are and economics are how does this take place and how do we finance the plan. You know, you start with objectives. My opinion is that you try to deal with things in a perfect world. What would we really like to have happen? And then go through the mechanics and economics to see if it can happen. If the results of that are that it can't happen because there's not the financing model in place, the objectives can't be met, then you go back and refine your objectives, but you don't start at the other end. The next slide then is further discussion on philosophy. So philosophy is ideas, convictions, fundamental benefits. I believe there needs to be a strategic plan for the business, First, I believe there needs to be either a family mission statement in a family business or ownership and operational statement. What do we want to have happen here in a non-family business? Then you apply those the mission statement or objectives to who, how, when, where, and what. The strategic plan for the business would be defining the direction of the company, defining the complexion of the assets, and determine if they're divisible, because in a family business, sometimes it may be better to parcel the business up to different family members than trying to push them all into an enterprise where you're creating a legacy of legal problems. And then, so you define the complexion of the assets. It's not uncommon for employed children to, in a family business, get shares of the operating company, and non-employed children to get real estate assets as a means of dividing things equitably. Then the application of the mission statement or the definition of objectives in a non-family business. Who should get either the business, the operating business, or the other assets? Should it be family? These are the only choices, basically. Family members, other shareholders, executives in the company, all employees via an ESOP, a charitable entity. We have examples of that in Northeast Ohio, where there are a couple that I know of, very large businesses that are operated in a charitable entity. That have hired executives. Could it go to outsiders, or there could be an initial public offering, which is costly, but I've been through one with an existing client, and sometimes that's the best avenue. Mechanics then cover all the tools and techniques of succession planning and financial and estate planning, the estate planning part, which we'll get into greater detail on today. This requires financial planning for the current owners. What's it going to take to make them financially secure? What is can you use retirement planning assets? You develop tools and techniques in estate planning, wills and trusts, which I'll get into in greater detail later. There needs to be financial planning and integration of that for the successors. I think that includes estate planning for the successors, or you could face failure, and then corporate planning, which some of these things have been covered, like in the November 7th S Corp C Corp partnership entity selection. Jim Awesome talked about that in his webinar. You know, what kind of entity should we have? Mary Gigante on in the November 19th legal documents talked about shareholder agreements. You could use supplemental retirement plans. It's not unusual for a sale to take place where a supplemental retirement plan is part of the revenue that's received by the seller. You have to look at the various transaction options, redemption, sale outright, so on and so forth. And I believe that there needs to be, in any successful succession plan, a formal board of directors to act in the segue. And certainly, if not a board of directors, a board of advisors. Most of my clients have a board of advisors. All corporations have a board of directors. Some are more active than others. Some include, in private companies, outside directors. Some don't. And in the evolutionary process of a privately held enterprise, first generation, we often come in and see a board of directors that is made up of family members. We like to get at least as a transition a board of advisors of outside non-shareholder people. And by the way, there are lots of people who are ready, willing, and able to serve in those roles. And we're not talking about compensation like public company boards of directors or advisors get. It's for reasonable fees. You can get very, very smart people to help your company and help in the transition, and provide advice on other things that they've seen. I like to, in the beginning, have my, if I have a client who doesn't have a board of advisors and only insider board of directors, ask their accountants, attorneys, bankers, financial planners, insurance people for names of people who may be candidates for that, and try to fill positions where you may have weaknesses. If you're a company that is looking to expand, maybe you could use the advice of someone who handles acquisitions. If you feel you need to be better in distribution or sales or finance or human resources, it's a great thing, and it provides a yardstick for you to measure yourself by, and turns out to be a very, very valuable thing for all my clients who have done this.
Neil, we just had a question come in, but you just answered it, so thank you.
Okay. Question typed in?
Yes.
Okay. Well, I didn't see that. What was the question?
Where to find?
Okay. Good. Yeah. That's the first place. I mean, in the position that I'm in the community where I know lots of advisors and I know lots of business owners, there are some of the best people are retired executives from corporations, from public corporations or private enterprises. I mean, there are just a wealth of great people, and I can't and of a lot of the work I do for clients. That is a very valuable aspect of it, getting them to do that. And start with doing it once or twice or 3 times a year. And you know what it does for the business owner? It gets the business owner to organize things and be accountable to someone else other than themselves and get to hear themselves walk through it. It's a very, very introspective thing. You know, it's like until you write things down and have to present it to somebody else, I think it takes things to a completely different level. And then the final component. So we talked about philosophy, we talked about mechanics, which we'll go into greater detail on, at least the estate planning aspect. Financing the plan. You got to have a valuation of the assets. I remember early on in my career, one of the questions I would ask a prospective client is, what's the value of the business, and they have some rough number in their mind. You need to know what that value is. In our process of wealth management and succession planning, we do cursory valuations on a template that we've created that is that really is pretty effective, at least at getting things in the ballpark when you're going through the planning process. Valuation is very important in family enterprises because it's just an insurance policy in the case of an audit, and it's something that's absolutely necessary. And that will be talked about in greater detail in the December 8th webinar, Business Valuations by Davin Gustafson, who's a great guy and I've done a lot of work with. And then you need to look at the transaction analysis, and that requires some somewhat sophisticated cash flow planning that involves first cash flow planning for the sellers individually. What's it going to take? Because in a family enterprise, the valuation of the business is sometimes what it takes for them to be financially secure, regardless of what the real value of the business is. Nobody's going to transfer a business that produces a lot of income to them, and nor should they, unless they know that they can be financially secure. And then there needs to be a cash flow model done for the entity, which would be owned by the buyers, and to determine what is the best way to push money out of the company to do this transaction. And you can look at taxes and effects, and you can present value these things. And so that allows you to look at different strategies and make a thoughtful analysis about the subjective and objective nature of it, and determine which one would be the best. And then run a heck in a handbasket scenario to see what happens if business sales drop off in the company, and how do we continue to operate this, and how does everybody act in this? You can't just look at what the best case scenario is, obviously, and you can't look at just what the current case situation or the B scenario would be, because right now for a lot of people it's the C scenario with the way the economy is right now. And so let's not get hoodwinked or snookered by our own numbers. Let's look at it in all scenarios. And then you implement the most effective strategy and create the resources for the funds. And so when you're in this economics and mechanics piece, it's there where you'd make some determination that, well, this can't happen. We can't meet our objectives. Maybe that happens, maybe it doesn't. It happens occasionally. And you go back and refine your objectives. But you start in the beginning with what can work best and move yourself through this process. So I'm going to now transition to the estate planning component. So now that everybody has a basic understanding of at least our approach to succession planning, successful succession planning.
Neil, a quick question. Is it going too far off topic to get a sense, a quick 30 seconds, 40 seconds on what the current state of the economy and the overall kind of effect it's having on business owners as they are going through this process?
Yeah, no, it's not out of line. I mean, 12 months from now, this might not be as relevant, but right now, businesses are having trouble borrowing. So I look at succession plans I've done in the past, and some of them wouldn't happen right now because, and not because the businesses aren't thriving, because by the way, my privately held clients across the boards are still doing well, which is, if you look at the S&P 500 and take the financials out, those companies are doing well. There's going to be some backlash, and there's going to be, some drop-off, which will be natural. But the driver here is the financial institutions are the primary cause of the at least the stock market part of things and the economy as well, because there are layoffs because businesses' capital structures changed. And there is still banks, despite the TARP, I think it will happen, banks still aren't loaning money, and they're calling in loans. They're not renewing credit lines when they should be because of their own circumstances, because the regulatory bodies are coming in and have questions about their capital ratios. And so they'd rather, even though they have people who are paying currently and in good shape financially, I've seen credit lines be threatened. So it becomes difficult to finance transactions like this. Alternatively, and we have a caller on here who is a practitioner, and he'll understand this very well. Alternatively, it is a very opportune time to do interfamily transfers. If gifting or transfers, gifting is a part of, or valuation at very favorable amounts is a part of a family succession plan, because there is no doubt, even if the company is still is operating and making money right now and on its own would be very valuable, discounts would apply based on comparables out there. And so you should be able to make more favorable, meaning at lower value, gifts of shares in company.
Neil, are you seeing a significant reduction in the multiples?
Absolutely. Oh, I haven't looked at multiples in the last 2 months because there aren't any to look at.
Right.
For the most part. But absolutely. You know what? And I've talked about this. I'll take another minute and talk about valuation. Valuation is approached in three. There are three ways to look at it: the assets, the earnings, and the comparables. Okay. The assets, to the extent you own real estate in you own your manufacturing facility, that's the value of that has gone down substantially. Not because necessarily the intrinsic value of it's down, but because there's no capital out there to borrow, and so there are no buyers, so the value inherently is lower on your real estate, a lot lower. I mean, everybody knows that with their house. Earnings, my clients are still making money. Their earnings are good. Okay, so that's not necessarily going to be in their favor. They're still having good years this year. That could change next year. It probably will change next year. And then comparables. I mean, if one of the comparables is any manufacturing company that's publicly traded, I mean, they've dropped. Their values have dropped precipitously. 80% precipitously. So on two of the three components, you're going to get a favorable. By favorable, I mean low value to make a transaction or transfer, interfamily transfer. So then multiples, I'm sure, have dropped. And then multiples are based on two kinds: strategic and financial. Financial multiples are what a financial buyer would pay for the business. That's somebody who's just an investor. Strategic is somebody who's going to buy it. There's going to be a strategic value. Inherently, it's going to drive a higher multiple. And that's typically the way it is, although I've seen when there was a lot of money in 2003 and 4 in the marketplace chasing deals, financial buyers were paying more than strategic buyers, which is strange. But typically strategic buyers are going to pay more than financial buyers. I'm betting, if I looked at multiples right now, that they're probably in the financial buyers probably 3, and a strategic buyer might be 4 or 5 times earnings at the most. And so those are low. Either in more normal times, they'd be 7 and 9, or 6 and 8. So yes, does that answer your question?
It does. Thank you.
Okay. So as we transition here into the estate planning techniques, because I've looked at the previous presentations, and we want to walk through the tools and techniques, and I've divided into 3 separate categories: minimal estate planning, basic estate planning, and sophisticated estate planning. And the sophisticated estate planning would be where some very favorable estate planning techniques would segue with business succession planning. But I mean, most estate planning is designed for an orderly and controlled distribution of income and assets, and it can do any of the following things: reduce estate taxes, defer estate taxes, or avoid estate taxes. If we go to the next slide, then I begin to talk about the minimal estate planning techniques. All assets are distributed really one of 3 ways, and most basically: by will, by contract, or by title of the assets. Titling of the assets, and by that I don't necessarily mean titling an asset in a trust, because we'll talk about that a little bit later in a couple slides further on in the presentation. I'm talking about titling of assets. Your home. Is your home titled joint tenants in common or joint with rights of survivorship? Most homes are titled jointly. So if a home is titled joint with rights of survivorship, which is often the case because the bank asks you if you got a mortgage, and you do that, or the title company or whomever. Rights of survivorship property title passes by the titling. If it's whoever is the other owner, if someone is deceased, it passes automatically, and that preempts anything else. It preempts a will, it preempts a trust, no matter what you've done. Joint tenants, there's a 50-50 divisible interest in it. By contract would mean beneficiary designations. IRAs, insurance policies, etc., annuities, named beneficiaries. So assets can pass based on the beneficiary designation in those contracts. And again, that preempts everything else. So those things happen in advance and outside the estate plan, and need to be addressed separately. Then you have wills. The most basic will just makes provisions about what's going to be distributed, and it names those things. So anything in the most basic estate, in the most minimal estate plan, anything that doesn't pass by title or contract would pass by will if you have a will. To the extent if you don't have a will, then your assets pass, the things that aren't titled, jointly or so forth, or by contract, will pass by your state residence laws with regard to intestate distribution. So then you've left it up to the estate to do your estate planning, and whatever your state law says is how those assets will be distributed. In addition, a will, there is a form of will that can have a testamentary trust component. So the next step from the most basic will, and I still call it minimal estate planning, would be a will that has a testamentary trust. It means that trust is created at your death, and assets that are named in that will go to that trust. And it's not as favorable as creating a trust during your lifetime, which is an inter vivos trust, which we'll talk about a little bit later. And the will then would contain executor, executrix. If you have minor children, who the guardian is. It might name specific bequests. This specific item goes to this specific beneficiary. Might have specific bequests to charity, and then directs all the residual assets that are not controlled by titling or beneficiary designation to whomever they should go. A minimal estate planning technique also that would accompany someone who would have a will, they probably would have, if they went to a lawyer to do the will and didn't do it online or something, durable powers of attorney, which are, in some cases, could be more important than the will itself. Durable power of attorney then is exactly what it says. It's durable. Rather than just a basic power of attorney, it allows an individual to act for somebody who becomes disabled or mentally incapacitated. It allows them to act for them during their lifetime as well. So it's signatory responsibilities, and it basically it avoids having, if someone becomes incapacitated, it avoids having to go to the court to in order to provide some legal planning or make signatures or open accounts and so forth. And then there's what you'll hear about is durable power, healthcare powers, and a living will, which Ohio has a living will, and the next slide will describe that a little bit. But the durable power, healthcare power, allows you to do the things that are mentioned on this slide, basically, in order to act for the person for whom you are our attorney. In fact, if decisions need to be made, if they're physically or mentally incapacitated, and there need to be health care decisions. So, and there are restrictions on that. You can't just pull the plug, but and you can read the slide yourself. But if somebody's in terminal condition, you can't you cannot just pull the plug. You need to have two physicians who agree and so forth. And if that's combined in the state of Ohio, and you'd want to look at your state specific, in the state of Ohio, if you combine the two, it gives you more distinct and affirmative powers, and it allows you to. And the living will is crafted by the person who is presumably incapacitated in this situation, and it spells out more specifically and gives better directives, so you don't wind up having to have either courts or physicians intervene. Another minimal estate planning technique, and this sort of starts to get beyond minimal, but I include it in here because it's basic, is annual gifting. A lot of people don't know that they can make gifts of, for instance, interest in their company, non-taxable, $12,000 per year per donee. Okay, so that donee means the person you're giving the gift to. So you can make a gift of $12,000 to as many people as you like. If you had enough people that you wanted to make gifts to, you could reduce your estate completely because you could give $12,000 to each of them. You can join together with your spouse then and make a split gift. That's $24,000 a year. In addition, each donor, the person making the gift, has $1 million exemption, which they can use. The $12,000 one is one that you if you don't use it, you lose it, because every year it goes away and you get another chance at it, but it goes away. The $1 million is once in a lifetime. The benefits to gifting are that they're real simple. It removes an asset from somebody's estate, and it can shift income. If you gave an interest in a piece of real estate that produced income, you can shift income from one tax bracket to another tax bracket. The disadvantage is it's gone once you give it away. And another thing a lot of people don't think about is carryover basis. Let's say you have an asset that's worth $1 million and you paid $200,000 for it. At death, that asset steps up in basis to $1 million. The beneficiary receives it, pays no tax if they sell that asset. The reason that is because those assets were subject to the estate tax system, and if it was in a high enough tax bracket, presumably taxed, so they're not going to double tax you there. But you do get carryover basis on a gift, so you want to think about the things you gift. The best thing to gift would be high basis, highly appreciating assets. Those things are rare.
Neil, question?
Yes.
On the gifting, does the gifting need to be solely to family members, or can gifting be done to outsiders?
It can be done to anyone. There's no restriction it's only restriction by amount. The $12,000 can be given away. You could give it away to you're in California, you give it away to everybody in California, your estate would be zero. But no more than $12,000 per person or $24,000 per person if you and your wife consent. The $1 million is based on what you're allowed to give away, and you can't give away any more than that without generating a tax.
Is that $1 million is a cumulative though? So
it's a one-time. Yes, but the $12,000 per annual doesn't get counted in that. Because
okay, that was my question. So the 1224 does not get counted.
Very good, very, very good question because it's confusing. Right. The $12,000 per year doesn't eat into that $1 million. That $1 million is standalone exclusively.
Right. Thanks.
All right. And that $1 million's been raised. When I started in the business, it was $600,000, and it wasn't inflation adjusted for a long time. And that $1 million becomes worth less every year as inflation eats away at it. And that $1 million doesn't change in the estate tax act that was enacted in 2001, and which I'll make reference to later. The annual gift exclusion does get inflation adjusted, and it goes up. It's going up to $13,000 next year. Okay, so that means $26,000 in a split gift can be given away.
But the Neil, a quick question. But the $1 million,
not inflation adjusted.
You don't see that changing in the near future?
No, and you want to know? I think that could get inflation adjusted. The reason that's capped. Because people are going to wonder about this all through next year, because obviously the government's not going to do anything with the estate tax legislation that's hanging out there, and I think a bunch of the listeners and people who will watch this webinar are wondering about this. When the Estate Tax Reduction Act was passed, it increased the credit every year, okay, and it disengaged what was a unified gift and estate tax credit. They were the same for a long time. It was $1 million and $1 million, for instance. That's because you get $1 million at death and you get $1 million at your lifetime. That got disengaged, and they increased the credit. The credit this year at death is $2.5 million. Okay, so that means $2.5 million or $5 million amongst a married couple can pass with no estate taxes. But the $1 million gift during your lifetime is limited, and the reason that that's limited is because it's because of the predictive nature of tax legislation. With the credit, they can predict roughly from mortality tables how many people are going to die and how they're going to balance the budget out in the future. With gifting, they can't, so they cap that at $1 million because they don't know when people are going to give that away, and so I don't ever see that number going up, to the way the credit's going up. Now, the estate tax, and I have a footnote on this later, the estate tax next year, the brackets drop modestly to 46%. The credit goes to 3.5, so now you're at $7 million for married couples, which is great because I think that takes care of a lot of small to mid-sized private companies. Okay, and then in 2010. We go to zero estate tax, so the credit doesn't matter. There's no estate tax. The estate tax is repealed, but because of the Byrd Amendment, because this didn't pass the Senate when it was passed, with 60% senators affirming, they cannot enact any tax legislation that goes longer than 10 years. The estate tax comes back at the 2002 amount, which is 50%. And the credit drops from 3.5 to 1 million. Okay, so we have 2010 of no tax and 2011 of going all the way back to what 2002 was. No one believes that's going to happen, and conjecture is that we're going to get, and now we have Dems controlling on both sides, and it's the Republicans who are pushing this. The Dems have even, in most commentary I read and what I think, have agreed that the credit is okay, that the credit would stay at $3.5 million per person, but the tax brackets will go back to, and who knows now with the way the economy is. They could go back to what they were before. They could go back. They could go to 46. They could go to 50. A year ago the talk was 35. 25 to 35. And in fact, I believe the Dems agreed to the credit being at 3.5 and the tax being at I think 35, and the Republicans didn't want that. They wanted the brackets to be lower, and so they came to no agreement on that. But that has to get fixed next year because no one in Congress wants the estate tax to go to zero, not with the kind of budget deficits we're developing. But what they do need to do is keep the credit high enough to keep private businesses from going under from estate taxes. Next slide then goes to this next step up, basic estate planning techniques. Anyone who owns a business, and lots of people who don't own a business, should have this kind of arrangement. And certainly anybody whose estate is larger than the credit amount should have a marital deduction and a credit shelter trust. And this is what's commonly referred to as an AB trust. And what this does is allows you to take advantage of the credit, the $3.5 million credit, if your estate's larger than 3.5. For instance, let's say we have a $7 million estate, and one spouse dies. Without the credit shelter trust, meaning the assets go into the credit shelter trust, you'll miss the credit. All right. So without having that, where the assets that credit amount can be directed there and held there, you'll miss the credit because you'll most likely leave everything to your spouse because that's the zero. There's no estate tax on transfers to spouses. So most people would leave all their assets to their spouse to avoid the tax. The credit shelter, AB trust, allows you to get the credit, still leave the assets available for your spouse. And so, for instance, in the $7 million estate scenario, $3.5 million would be applied to the credit exemption trust, the B trust, and the other $3.5 would go to the A trust for the benefit of the spouse. And the B trust also could be for the benefit of the spouse, but first and foremost, generally only distributing income, but available to that spouse if the A trust is consumed. So it's the best of all worlds. In the absence of that, you missed a $3.5 million credit by leaving everything to your spouse to avoid the estate tax. So it's monumental that someone have this, and that they understand that the implications of not having it. And then that slide goes on to describe some of the things I already talked about. And in further detail, then you can also have a qualified terminable interest property trust, which would be the A component of that. So that's the trust that would be set up initially for the spouse, which would, and in this case, you'll see this trust. I have it with both married couples, first marriage, and oftentimes, and most often, in second marriages, it allows you to leave the assets for the benefit of your spouse, but does not allow that spouse, which would be common in a normal A trust, to appoint that property to anyone else. In the case of, for instance, a second marriage. And I've seen spouses look at each other and say, you know what, we both want Q-tip trust because one of us will predecease the other, and one of us may get married, and we don't know what kind of influence they'll have, and we both consider and say we want the children of this marriage to receive the bounty of our estate, and so we're going to both have Q-tip trust. And what the Q-tip trust does is allows you to give it to your spouse and still qualify for that marital deduction, but control who gets the assets. So it's sort of like reaching from the grave and having some control that the IRS normally wouldn't want you to have, because if you had it, it wouldn't qualify for the marital deduction and you'd pay estate taxes on it. It allows that to happen. This is a very common trust and is very useful. And particularly useful in a privately held enterprise if the estate is such that some of the privately held enterprise is going to end up in that A trust to defer the tax. And now we get into some of the things that are a little more sophisticated, because I could still call the AB trust under a basic estate plan, but I put it under sophisticated. The split interest trust. Now this is where you're trying to drive to get some make some favorable gifts and transfer of assets, and it can be integrated with succession planning depending on what the asset is. for instance, a charitable remainder trust and all these split interest trusts, what they do is they split the interest between the income asset and the remainder asset. And I see that we're kind of running up on time here, so I'm going to go through these quickly because I do want to get to the case studies. And Chris, it's okay if we run a little over, right?
Yeah, I think that's fine. I really believe this is good stuff, so
right.
I think we should try to.
And I think the charitable remainder trust is a little less applicable and less common in a succession plan, so I'll breeze through it and get to the other split interest trust. But basically what it says is this, and this applies across the board whether it's charitable or not. Let's say, I'll give you an example. We have a piece of real estate that's worth $1 million, and we're planning to use that real estate to we would like to sell it and provide income in our retirement. So, and let's say our basis is $200,000 in that real estate. So we'd have an $800,000 capital gain. And when you looked at that at capital gains rates and state tax brackets, you're going to generate about $175,000 of tax to do that. Alternatively, you could make a gift to a charitable trust. The charitable trust then would make payments to you over your lifetime based on annuity tables and rates that the IRS publishes. So you would make a gift of the million of the property. The charitable trust then would sell the property, so the whole $1 million would be available to provide income to you. The beneficiary, the remainder interest beneficiary, would be the charity, and you would receive income over your lifetime. And let's just say that you receive your right to receive income based on your life expectancy and the interest rates is $800,000. You would have then you would have made a $200,000 charitable gift, because you're going to be receiving present value over the rest of your lifetime, $800,000 of income, but you get a current tax deduction for that. So it's a very neat way to get, and I've seen this integrated in businesses, even with operating companies, but more often with real estate, as a way to benefit a charity. You need to be charitably inclined. This isn't just a tax idea. This is something you need to have some charitable inclination, that it's a win-win for everybody. And then you go on to the same sort of thing can apply to a family business. And I think that examples speak better than words. It's the same concept, okay? And these can be annuity or unit trusts, which is beyond the scope of this, but the calculations can be based on annuity tables or percentages that are paid out. I did one of these that I think is a very good example. Company stock worth $4 million. The company is growing at a pretty substantial rate and making substantial S distributions. It's an S corporation. A $4 million gift of stock is made to this trust. The beneficiaries are the children who are going to be operating the business. The trust is going to pay out S distributions of about $500,000 a year, based on the amount of the stock, and that's going to be paid over a period that we select, 10 years. So it's going to pay $5 million out over 10 years. Present valued, that's some number that's below the $4 million based on the rates. And the gift value then, let's say that number calculated to be $3.8 million, the present value of those payments. We only use $200,000 of someone's gift unified credit. And in this case, this client had enough beneficiary children, a lot of children in the business, that we were able to do it with split gifts. And our taxable gift was only $90,000. Our gift that used the unified credit of $1 million. So in combination, using the annual exclusion and the gift, the unified credit, we only used something like $90,000 of the unified credit, and the rest of it was the annual exclusion. So we gave $4 million away for a gift of $200,000 and never paid any estate taxes because we did it all under annual or unified credit, and the business asset winds up in the kid's hands at the end of the term of the trust. It's important that you feel confident the business is going to outpace the rate that you use to do the discount calculation on the fair market value. If it doesn't, then it's a moot point and shouldn't be done. You should do something else. The same concept can happen with a house, and I'm not going to go into great detail. You can read the slide here, but the exact same thing can happen with a house, except the house doesn't produce income. But what it does is what is used as the income interest is your right to live there and what it would cost, for instance, in rent to live there over that period of time. Often done with a second residence to reduce estate taxes, to give away an asset that's appreciating rapidly in this marketplace. The asset wouldn't be appreciating rapidly, but it'd be valued very low. And so I think that there's some opportunity for foresighted people to use the qualified personal residence trust. And we make sure that I've done these. The grantor has the right to use the house for the rest of their life. And if it's at the end of the term of the trust, they may even have to. We may require them to pay rent, which is a good thing because it's a way to make gifts to the children that's counted as rent, but doesn't go against your gift exclusion. So on the surface, sounds weird and not so good, but it actually works. And then family limited partnerships, which I consider estate planning tools, they have to have business purpose and must have that. But have been covered by previous webinars, and I've just included these slides, but anybody who's watching only this one should go back to the previous webinars, and you get a greater detail on that. And then finally, irrevocable trusts with crummy powers. These are oftentimes insurance trusts where you're putting insurance. You're making small premium payments into the trust for large death benefits, and it's a way to leverage gifts and get the insurance. No business owner should own their insurance either in their company or personally. It's ridiculous. It's estate taxable. Most people don't think it is. The insurance in somebody's estate could be the thing that throws them over the top and beyond the $7 million of credit we're going to have next year. And it should be owned in one of these kinds of trusts, and it gets people to exactly the same place they wanted to get, whether it's income for spouse, money available for the business, what have you. One more item is a sale to defective grantor trust, which I won't go into great detail on, but it is a very interesting tool and allows you to sell your business to yourself, essentially, over a term where at the end of that term, it becomes an asset. The asset becomes your beneficiaries, your kids, for instance. And I've used them in non-family transactions too. And basically what it is, you set up a trust, you make a transfer, you make, those trusts need to be seeded, meaning there needs to be something in that trust because you're going to do an installment sale with that trust of your own company stock. And if that trust has no assets, then it's not a real transaction. The IRS won't view it that way. I don't view it that way. So the trust has to have some assets to be a viable entity, or no one would do an installment sale with it. And then you use your S corporation stock, you seed it with a gift, and then you sell the balance on an installment basis. And basically you do the back financial calculating, so the S distributions that you were already receiving are going to be used to come through that trust as payment for the sale of the stock. And they get the same tax treatment as if you own the S stock outside, so you're paying income tax on that, but avoids all capital gains. And at the end of the term of the trust, the stock is gone, and so is however many years the term of the trust is, so is the appreciation. So in an appreciating company, it's a very, very interesting tool and something we've used with clients. I'm not going to talk about generation skipping exemption. You can read about it on the slide, but you have to be wary in your trust documents that you do, in fact, address, and I cover it in pretty good detail on these slides, address the generation skipping tax exemption. Make sure you're using it if you have trusts. Make sure it's being applied if you have trusts that are going to go down beyond the next generation. And finally, I'm going to just go over, because we're going to run up on almost an hour here. I want to give you at least two examples here, and I gave you the free bonus case study last. But this is a real live. This is a friend of mine who was a lawyer with the IRS. And this case is published out there. I've read it in stories and so forth. Was the IRS agent on this case, on this estate. And this is an example of where poor estate planning collides with poor corporate planning, and there's a complete lack of integration and foresight. it's, you look, when you read it, it's pretty common. So in 1966, Harry and his sons Stan start a business, and Harry's two other sons, Patrick and Arnold, never come in the business. Also a common story. Stan becomes a big contributor. Harry makes a gift over, a period of time of 35% of the stock of the company. Stan's two kids, Stu and Ellen, come into the business. Harry wants to make Stan a 50-50 partner, get him up another 15%, but Stu, being foresighted, says, don't give it to me, give it to my kids, because these two kids are going to be coming in the business, and hopefully they used their generation skipping exemption there and didn't generate any generation skipping tax, which is nasty. And so they needed to formalize some kind of succession plan. The main issues here are that a corporate entity. Should this company be a C Corp or an S Corp? And this company at some point post these transactions became an S Corporation. Shareholder agreement needed to be put in place. Their estate plans needed to be addressed, and there needed to be a valuation of the company. That's not to say that it happened. I'm just saying that's what needed to happen. Then during Harry's lifetime, his wife died in 1984. Harry started to think about his estate, which is natural. About that time, Stan's son bought 10% of the company from Harry, his grandfather, for $300,000 and a 10-year note. At that point, then, the ownership was Harry owned 40%, Stan owned 35%. Harry's grandchildren, Stu and Ellen, owned 17.5% because Stu bought 10%, and Ellen has 7.5%. Her original son of 7.5% that was gifted by Harry. Stan, while not a true majority shareholder, at 35%, exercised control of the company with Harry's blessings. Unfortunately, after all this happened, Stan was murdered in a robbery at one of their stores. And pursuant to a shareholder agreement they had in place, Stan's wife became the owner of his shares, and Stan's family owned 60% of the business. Harry lost his partner and son, and Harry started to become excluded from the corporate decision-making process because the family dynamic changed. And while he was still compensated by the business, he'd become an outsider. After Harry's death, the shareholder agreement was again triggered because Harry was a party to it, and there was supposed to be a redemption of his shares. But the valuation of the shares was delinquent because you should have valuation provisions in your shareholder agreement, which Mary spoke about in her webinar, but they hadn't updated it. Very, very common problem. See it all the time. That's another thing that a board of advisors or board of directors will force is at that meeting talk about re-evaluating the valuation. So this valuation was stale. A protracted legal battles began, and Stan's brothers, Patrick and Arnold, were the executors of Harry's estate, and they were the beneficiaries of the balance of the estate, which again is not uncommon. Balance of the estate goes to kids who don't get a piece of the family business. The business continued to operate, but the family was in a big legal dispute. While time passed during all this litigation, and there were battles going back and forth on valuation, and lawyers were getting rich, the executors owned 40% of the corporation. Okay, because they of this S corporation, because it was in the family trust in Harry's trust, and the buy-sell hadn't been consummated for the redemption to happen, and so the trust owned it during that period of time. The majority shareholders, 60% shareholders, Stan's family, shut off the S distributions because there's no obligation unless it's stated, and I require that in all buy-sell agreements that tax payments be made to all shareholders. It's a common mistake, and it's one of the most important things in a shareholder agreement. The state assets, other assets like Harry's house and things, had to be liquidated to pay the $800,000 of income tax that was due because the company was still making money, and the shareholders who owned 40% were attributable. Those earnings were attributable to them. Patrick and Arnold even had to contribute some of their own personal assets to pay the taxes. To top it off, when they finally came to a valuation number, which was somewhere in the vicinity of $12 million, the shares were redeemed because that's what the shareholder agreement called for, which is a bad outcome for a lot of reasons, not just because there are code sections under 302 that govern this, but because when you redeem shares, you get no step up in basis, okay, which is a bad deal. So your basis remains the same. You might own, Stan's family owns now 100% of the company on a redemption, but their basis and their shares never changed. So if and when they sold the company, they would have a substantial tax. If they'd done this transaction outside, meaning shareholders bought it with money that came out of the company in an S distribution, which is easy to do, problem would have been solved. But the IRS deemed it a dividend, when that's a dividend rather than a transaction where they should have gotten $5 million for their shares and with a stepped-up basis in the stock, had paid no income tax, got $5 million tax-free. They paid income tax on the $5 million, and so the estate generated an income tax of $2 million. They netted $3 on something that should have been $5. So this was just a nightmare. And all of this happened because of a lack of integration and a lack of foresight, a lack of understanding from an entity planning standpoint what an S corporation, what the problems associated with the S corporation, a faulty buy-sell agreement, which they thought they had a business succession plan in place because they had a buy-sell agreement. And sometimes a bad buy-sell is worse than no buy-sell at all. And then they never took the time or never looked at the implications. So this is a catastrophe. And then to close this out, and this is shorter because there are less problems, this would be an example of a client of ours who's a first-generation business owner, and their successors are a sibling company. Actually, I'm going to skip this one. I'm going to go to the last one because it's a little more interesting and a little more complex. This is a second-generation business. Clients were second-generation owners, two brothers in a business. And the successors were cousins. The one brother had some kids in the business, and the other brother had none, but wanted to leave open the opportunity for those kids to come in. The brothers wanted to maximize their gifts. At the time, that was $1.2 million. The credit was $600,000. They could split gift. They wanted to give away $1.2 million of their shares because they wanted to start. They thought the company was going to appreciate, which it did. They wanted to make those gifts sooner than later. They wanted to transfer shares only to employed children, but allow the other children who are coming into the business to get shares in the business. They wanted to equalize to kids who didn't come in the business if they so elected. And in the third generation, this was now going to be, this company was going to be employed by family members, and they were going to be cousins, meaning they must, in some cases, if both brothers' kids, some of their kids came in the business, we would have a cousin company. So the issues were, what's the most tax-efficient way to make a lifetime transfer? How do we define what qualifies for a child to obtain ownership? What are the methods for the distribution to the employed children only, and value the non-employed children in lieu of ownership? How do we do the economics of if somebody gets the business, what else do the other kids get? How do we control the business during the lifetimes of both brothers? During the time when one brother is deceased, which has happened, and the other brother is still an owner, how does he not be in direct control partnership with the other brother's kids? And we gave him veto power. And then how do you finance all of this? And the results were, we set up formal criteria for kids to qualify to own shares. We set up trusts for each brother to make gifts to, where all children were ultimate beneficiaries of those trusts, but only if they qualified for ownership in the business, which was defined by job description, level of company, level they rise to in the company, and number of years worked in the company. And so these brothers were able to make their maximum gift. They were able to feel comfortable that their kids would have the right to own shares. They were able to feel comfortable that they would still be in control if the other brother is deceased, and wouldn't have to account strictly to the children of the deceased brothers. And we developed financing methods, which were salary continuation plans, so that the brothers could be. We set retirement dates for the brothers. We used voting trusts so they would have veto power and control during their lifetime. And I've watched this plan go through. And it's worked. And the third generation is running this business, and without any issues at all. And we've had a deceased shareholders. Everything's worked. So it's gratifying. And I'm going to end there. There's another case study that I skipped over that you can read if you want on your own time. Do I have any questions or comments in the end?
Well, I have a comment. The two case studies that you cited really show the difference between when you think things through and when you don't. And my question is something that comes up often. How do you convince, oftentimes business owners are reluctant to discuss some of the possible contingencies that could happen. No one would like to think about a time when a son would predecease oneself.
Right.
How do you convince people that they really need to think about these things?
I think in the beginning, most no one wants to think about their mortality, of course. All right. But I think in the beginning, and this happens in baby steps. It doesn't happen overnight. It's a long. By the way, it's a process, not a product. Okay. There's a beginning point, and there's really never an ending point. There's a point where it just continues on, and it has to be dealt with as a process. If you can get a business owner to understand it's a process by which they can make baby steps. You know what? This client in particular took a couple of years because we had difference of opinions with brothers on how things should happen, and because they had different objectives. But if given the audience, I think that most business owners don't make any plans, make minimal plans, because they either have not spent any time to define the objectives, which I can't make somebody define their objectives, but I can help them, and if they have any inkling of doing that, we can make it very painless. And then for those who haven't defined their objectives, I think a lot of them think, or have only defined some of them, I think they think there are no options to meet their objectives. For instance, I think a lot of business owners think that they don't know that they could transfer almost all of their business to somebody else to alleviate their estate tax problems. However, at the same time, keep control of income. There are three. You have to think of it like this, and I see a light bulb go off with some business owners in the beginning of the process. You have to think of your business. You have three rights in your business. You have the right to income, you have the right to equity, and you have the right to control. And those things are all divisible. And in the end, mostly all you want is control and income, because that's financial security. You can have that and make substantial transfers of your business. And I think that I can think of several clients who didn't know that could happen. And then you have to also drill down to try to figure out, and it takes time, and you have to deal with not the tax issues, but the philosophical issues. You have to drill down to see why that hasn't happened. We have I don't have this case study included, but we have a very, very good client where we've done very successful wealth management and succession planning. And this client I happen to know because we're a small community, and because the prospective client told us everybody in the world had been through that guy's door to try to get him to do the things that he needed to do, and he wasn't doing them, and including someone in our firm. And so I'd heard this name for a long, long time. This is 15 years ago. I said, you know what? I take it as a person. I got to figure this out. I can't figure out why this hasn't happened. Take me out there. I want to see this guy. We went into the office, and I walked past one sibling's office, and there were two stories. In the one sibling's office, the sibling who was older and been in the business longer, his office was with a very important position in the company. His office was on one floor. The next floor up was the dad's office, and another sibling who'd been in the business a shorter period of time, his office was next door to dad's. And I came to the conclusion that dad had not made any gifts or made any transfers because he didn't know how to deal with that issue, and that if there was an issue there, that how do you tell the kid who's been in the business longer that you maybe want control to happen or some veto power to happen with his younger sister, and so I realized that was the problem, and that person didn't realize that those issues could be dealt with and dealt with fairly, and we could have equal ownership and even mostly equal power with some veto power. That client happened to think, and I would disagree with that on the surface, that one person needs to control. And I disagree with that on the surface only if we can make a determination that the fact pattern's right. And that's a talk for a different day. I've spent an hour talking about that subject, where co-leadership works and where it doesn't. And because I saw an example of it, because the case study that worked that I just talked about, those were co-leaders. Those were brothers in a business, and they had different duties. They had respect for each other. They were honest with each other. They communicated with one another, and they had equal views on risk. And because of that, that worked. And so you have to look at those things. So you have to get people to start to look at their objectives and to understand, most likely, you're not the only guy who's been through this. It can work. It can be done some way. It doesn't have to happen all at once.
Right. And what I find amazing is those where oftentimes people have their offices in conjunction with one another can tell you a lot about what's going on inside.
Absolutely. You got to look at the body language and the physical everything. I mean, the physical layout of a company tells you a lot of things about people.
Sure. Do we have any other questions out there? Comments?
This was really great stuff. Thank you.
Oh, you're welcome.
Great. I think we're going to wrap it up. Again, I would like to echo the statement that I thought this was a lot of good stuff, which is why we went ahead and ran a little bit long, because I thought a lot of this stuff needed to get out there, and some of those examples were really telling. I want to thank Neil Waxman from Capital Advisors, financial advisory firm in the Cleveland area here, for coming and giving us the benefit of his knowledge and experience. I want to thank the folks for joining in, and I